Anybody can go down to that probate courthouse and see what the terms of your will are. That is a public process. And so that very often for the families that we work with is a big no-no.
Does that mean that just anyone can walk into a courthouse and basically get a copy of your will that says, hey, the $2.5 million beach house in Ocean City goes to Sally?
Yes. Yeah. And if you ever read the news and you hear about all these celebrity estate challenges, that's the reason why you're able to know about those things. If you're only relying on a will as a part of your estate plan, just be aware that that's going to be something that is a public process.
Hello and welcome to the show. I'm your host, Alex Daly, Managing Director here at WorthNet. And today we're going to dive into one of the most uncomfortable subjects in financial planning, death and taxes. Today we're joined by Michael Priest, a tax attorney at planning firm Copper Beach Financial. Michael and his team have long focused on multi-generational wealth planning issues, how to build plans intended to protect assets, from in-laws, outlaws, and thieves, as they like to call the forces that would limit your ability to grow wealth through the generations, such as taxes or unexpected financial issues. I'm really excited to sit down with Michael and dig into what are the various components of an estate plan and what tools do they bring to bear designed to help limit taxes, protect assets, and ensure that wealth. We're going to go deep on the tools and techniques that Michael and his team use. So just a quick reminder that everything here is meant to be educational. If you're looking to build an estate plan for yourself, it starts with working with a professional. Consult a tax attorney or wealth management practice with experience in this area. Michael and his team would be glad to be that resource for you. You can go to worthnet.com and reach out to Michael and his team to start your own planning process. But either way, be sure to consult a professional before you deploy any of the sophisticated techniques we're going to talk about. But before we dive deep into those techniques, we're going to take it from the beginning and break down the various components of an estate plan. What role do wills, trusts, life insurance policies, powers of attorney, and various other tools play in managing an estate effectively? Michael, welcome to the show.
Hi, Alex. Thanks for having me on. Looking forward to talking today.
Yeah, really excited to dig into this topic. It is, frankly, one of, I think, the most uncomfortable topics in financial planning, but also one that can have one of the biggest impacts on your family if you get it right. Now, Michael, you guys concentrate on multi-generational wealth management, I think you call it, in your firm. So I really wanted to sit down with you and sort of build the definitive course. What is estate planning? What are the major components? What tools and techniques do guys like you bring to bear to help effectively manage wealth across generations and really help provide people a baseline education so they can ask the right questions when they engage with a wealth manager like you or anyone else? So, Michael, help us understand, what is an estate plan composed of? Is this, I just go to an attorney and I say, hey, I want a will? What are the big pieces here?
Well, I think that's a great question. I think to define what estate planning is, I think at its core, it really is, I like to describe it as sort of the legal plan that provides clear guidance around what happens to you, your assets, and your loved ones in the event that you can't take care of those activities yourself. So either you pass away or you become disabled are really the two main things where you can't take care of those things for yourself. And so the estate plan is going to form the framework around how you would want those wishes carried out.
And so what tools do you use to build that plan out? Is it as simple as I just need a will? I hear often the use of trusts. Like, can you explain the major components that go into a plan?
Sure. I think that there are probably four, I would say, foundational estate planning documents that really everybody should have. And the first one, as you alluded to, Alex, is a will. The second would be a revocable living trust. The third would be a durable financial power of attorney. And the fourth would be a healthcare power of attorney or living will is another term that is used commonly. Those are really the four foundational legal documents, and they all do a little bit different things, which maybe we'll get into. But those would be the four, like really the foundational pillars of what an estate plan would be.
All right. So if I got that right, it's a will, it's a trust. We'll get into what you mean by these words like revocable, living. And I know that there
Yep.
are a lot of different forms of trusts, things like charitable remainder trusts and
Yep.
irrevocable trusts, grantor trusts, etc. And then these two power of attorneys, a healthcare power of attorney and a financial power of attorney. Did I get that right?
You did. Well, if I was going to just describe these documents are oftentimes, I say oftentimes, maybe even forgotten about in an estate planning context, because a lot of people that are going through the process really look to the will as being the only component of an estate plan. But these documents are really important as well. So a financial durable power of attorney is a document where you would nominate somebody to make financial decisions on your behalf if you are unable to do so while you are alive, which is the key component. So if, God forbid, you get in a car accident and you become disabled and you can no longer make banking transactions or make real estate transactions, you would nominate somebody to act on your behalf in that capacity. A living will or a healthcare power of attorney is a similar concept where you would nominate somebody to act on your behalf, but it's really to deal with healthcare related decisions if you are no longer able to make those decisions. So end of life decisions, if again you become disabled and you can no longer make those decisions for yourself, you would nominate somebody to make those decisions, and you would also outline how you would want to be treated in the event that you couldn't make those decisions for yourself.
That's a really salient point. You said that right at the beginning, and I don't think I really quite grasped it. But that, we think of an estate plan as death, right? But it's about more than that, right? It's about when you can no longer care for your family, for your community, and for your own finances, right? So that sounds like a really important part of it. I want to get back to it and sort of the nuances of that document, but why don't we start with the first thing in your list, the will?
Sure.
Because you guys, some of the first times I sat down with you, your father, John, who founded the firm, who's been practicing in this business for more than 40 years, you guys take an interesting approach to wills as maybe not the most secure or positive document. Can you tell us, what is a will? What are its upsides? And what are the downsides and risks to using one?
Sure. Well, a will is a foundational estate planning document, and it primarily deals with how you want your assets to be distributed upon your passing. But it has also a very key component as well, particularly for individuals that are going through this process that have younger children under the age of majority. As I always say this to families as they're going through the process, the most important thing that you should have in your will is naming a guardian in the event that you or your spouse or the other parent of that child is no longer here. Is who do you want to have to raise that child to the age of majority? If that is not spelled out in your will, then it becomes more of a court appointed process where somebody would be nominated as that guardian. So that's a really key component that a lot of times folks don't appreciate or understand that component because they think that a will really just deals with assets, with money, bank accounts, things like that. It really has a more of a foundational component with regard to, family planning in terms of that situation. God forbid if it ever were to happen. But the other component is really more around how you want your assets to be distributed upon your passing, because wills are sort of interesting or funny legal documents in that they do not actually become legally effective until you pass away. So at any point in time while you are competent, you can rip up a will, create a new one to change things around if you want to do that. But because you are no longer here to enforce the terms of that will, that's what really brings in the probate process, which I think gets to your second point around why maybe only having a will is, you certainly should have a will. It's, again, one of those foundational documents. However, only having a will can provide or cause some additional complexities or, let's say, less desirable results around how that estate plan operates. So maybe hopefully that answers your question. Maybe we can get into a little bit more about that probate conversation. I think that'd be helpful.
Yeah. Before we get into those potentially unexpected outcomes, so tell me, what exactly is probate? Hear that term all the time. Never managed a family member's assets other than passing to a spouse, which I think is a much simpler process. What is probate? What happens? And what is it that you should be looking out for? What are the big sort of risks and gotchas in that process?
Sure. So the probate process is a court supervised process that really enforces the terms of that will. So, as I mentioned a little earlier, these documents do not become legally effective until you've passed away. And so, as a part of your will, you will nominate somebody, which is called the executor, that is responsible for making sure that the terms of that will are enforced according to your wishes. And in order to make sure that that process operates smoothly and effectively, the courts and really almost every county in the country has some form of probate court that will be overseeing that process to make sure that the terms of the will are enforced, any debts of the decedent are paid off, and you notify creditors that there may be an estate that is transferring. And if you have a claim against that estate, you would be notified to make sure that you have to submit that claim to, be paid whatever is owed to you. So it is more of a court supervised process. And the downside oftentimes is that it is a public process. And this is something that we ask all our families when we go through an estate planning review is tell us if your estate plan is public or is private. And very often we get kind of blank stares because they're not really sure why we're asking that question. And really what we mean by that question is your estate subject to probate or is not? Because the probate process is a public process, which means that anybody can go down to that probate courthouse and see what the terms of your will are because again, the executor has to notify potential creditors that you have passed away and that the estate is going to be settled. So that is a public process. And so that very often for the families that we work with is a big no-no. They don't like having what they have in their estate, what it's worth, who they're going to leave it to, all of those sorts of questions. They don't like that being in the public realm. And so the important thing is to just recognize that if you only have a will, that is a public process that again, very often is less desirable for a lot of the families that we work with.
Let me make sure I understand that. Does that mean that just anyone can walk into a courthouse and basically get a copy of your will that says, hey, the $2.5 million beach house in Ocean City goes to Sally, and $1 million in this account goes to cousin Ben?
Yes. Yeah. And that's one of the reasons why if you ever read the news and you hear about all these celebrity estate challenges, that's the reason why you're able to know about those things in the public sphere is because journalists that are interested in publishing those stories, they can go right down to the courthouse and find out whether you had a will or you did not have a will, and they're able to supervise that process. So again, it is something that's less desirable for a lot of the folks that we work with. It's a concern for me. And so it's one of those things that, again, if you're only relying on a will as a part of your estate plan, just be aware that that's going to be something that is a public process if you were to pass away.
Yeah, that's a really good note. I mean, it makes for a great celebrity gossip column, but it also sounds rife for financial abuse, scams, those kind of things.
Sure.
How do you not be public? You asked that question. You said, is your estate plan public or private? How do you make it private? Is this something where you go to the court and you ask to seal the records or something?
No, unfortunately, that's not available. The main tool that we use is a revocable living trust. That's that second foundational document that I alluded to earlier. And any asset that is owned by a trust at your passing will bypass probate. And so that is again a foundational document that we would incorporate in an estate plan that if the client or the family that we're working with is concerned about having a publicly settled estate and they wanted to avoid that, then we would help them and guide them through the creation of this trust vehicle to be able to utilize as the vessel, if you will, to be able to receive those assets to avoid that probate process.
All right, I'm going to play the rube here a little bit, and if I'm telling you the truth, Michael, I'm not even playing the rube. Help me understand, what is a trust? You called it a vehicle. You referred to it as a trust. You hear that term all the time. Can you kind of explain to the layman who's not an attorney, what is a trust?
Sure. The trust is the simplest way I can describe a trust. It's a legal relationship where somebody or a person holds legal title to property for the benefit of some other party. So that person that holds the legal title is called the trustee. Some of your listeners may have heard of that term before. The person or people that is that the trustee is holding those assets for are the beneficiaries of the trust. And the grantor is the person that creates the trust. So in a family estate planning context, I'm, as the grantor, the creator of that revocable living trust, I am the creator, the grantor. I would nominate some person as the trustee of that trust. They would hold legal title to that property, whatever property I transfer that trust, on behalf or for the benefit of some other individual. Could be a spouse, it could be myself, even it could be my children, grandchildren. It really depends on the plan, but the trustee is the person that holds that legal title to that property. Those are the three main roles of a trust.
Okay, so the trustee holds the legal title, but they hold it on behalf of someone else, right? So can you,
Correct.
as a trustee, I mean, are you just appointing your executor all the time, or like what are the choices for trustee? What should you think about as you establish a trust in terms of what you want to see in that trustee, and what kind of options do you have?
That's a great question. And very often the trustee that you may choose in your estate plan would also take over the executor role. They're technically two different roles. So the executor manages the will process. The trustee can be the same person. It may be a separate person depending on the plan of the family and who they want in those roles. I often say that the executor role is a more temporary role, whereas a trustee could be a very long responsibility depending on how that trust is drafted and the terms of that trust. Then that could impact who you want to pick in those roles. But when we go through planning, often picking a suitable trustee for that family is very often one of the more challenging parts of the whole estate planning process, because it is a very important role. It's a fiduciary responsibility. So that trustee has the fiduciary obligation to act in the best interests of the beneficiaries. They have the fiduciary responsibility to enforce the terms of that trust. And so very often who the family picks to fit that role, or fill that role rather, is really important. We spend a lot of time with our families as a part of the holistic planning that we do to really make sure that they understand that how the role operates, and picking the right person to fit that role. It's vitally important.
Gosh, when I think about my own situation, I think about my knowledge of investing, and I think about that versus effectively everyone else in my family. I think in many families, there's one source of wealth, right? One family business that was successful, run by patriarch, a matriarch, an uncle, whoever who has had that success and has learned, the mistakes and the hard won lessons that can only come with managing money over a long period of time. How do you manage that risk, if you will, that you're going to choose the wrong person, or they're not going to really understand how to manage wealth that you've accumulated once it passes on?
Yeah, that's why it's a difficult choice, right? I think you hit the nail on the head. There's really three main responsibilities that the trustee has. One is to make sure, again, that the terms of the trust are enforced. So making investments in the trust. So depending on their financial acumen, that's an important responsibility. They also have the responsibility to make distributions of the trust's assets out to the beneficiaries, depending on how the trust is drafted. And then they also have administrative functions like maybe filing tax returns, or things like that. So those are the three principal roles. Now, there are ways in which you can appoint certain trustees to handle components of those responsibilities. So you may have an investment trustee or a distribution trustee. That's maybe getting a little bit into the weeds, but there is flexibility with how you can draft these trusts to accommodate that. And we often say that when we draft trusts, we like to have a lot of flexibility. So we like to have the ability where, if that trustee, whoever that person or people may be that you've nominated for that role, if they're not working out, we want to have language drafted in that trust to make sure that either the grantor, depending on the circumstances, can remove and replace that trustee. We also maybe want to have provisions in there where the beneficiaries of the trust can remove and replace the trustee. So we want to try to have a lot of flexibility to account for those situations, because it might just not work out. The trustees can always resign. So they may just say, hey, this is not really for me anymore. I want to resign. We want to have language in there that nominates maybe a successor trustee. So you have a lot of flexibility with how you design this estate plan to make sure that you're accounting for those different circumstances. It's not always going to be perfect. So really never going to be perfect, but we try to design this plan in a way that you, as the family, as the client, are understanding all these components to make sure that you're thinking about how we might want to draft this to benefit your family. It's very, very important.
It sounds a bit like sort of contingencies upon contingencies. Like, hey, I
Yes.
want this person to take over in this event, but if they're incapacitated, I have a substance abuse problem, they have a bad marriage, they have whatever, I want to have this backup plan, and this backup plan to the backup plan is what it sounds like. So get back to the trust for a second, right? Because we talked about those roles, right? You have the executor on the will. Now we have assets moving into a trust, this legal vehicle, and I'm going to butcher the legal terminology because I am not a lawyer, but you have it moving into this legal vehicle that sort of sets the rules of who's going to manage that money, how they're going to distribute it. But you used very specific language. You called it a revocable, did I get that right? Or irrevocable living trust.
Revocable.
Walk us through those two words. What do they mean? What's the significance, and why might someone choose the opposite or a different variant of a trust, even if not for estate planning?
Sure. It was a great question. So revocable trusts are trusts that are revocable, meaning you can change them. So just like I mentioned earlier, where as long as you're competent to change your will, you can do that at any point in time during your life. It's very similar with a revocable living trust. Living meaning you're creating it while you're alive. And so you have the ability to change it. You can move money back out of it. You can essentially create it and change it as many times as you want. An irrevocable trust is something that you cannot change, or you can't change very easily. Many states are making it a little bit more easy to do that, but historically, irrevocable trusts, once they are created, they cannot be changed. And once property is moved into that irrevocable trusts are actually a separately legally distinct entity. So they have their own tax ID numbers, which means when you transfer property to that trust, it is now the property of the trust. If I'm the grantor and I form that trust and I move an asset into that trust, I am no longer the owner of that trust anymore. And because it's irrevocable, I cannot change it. So that's the very key distinction between those two trusts. Now, why would you use an irrevocable trust? Because it sounds like, well, I would just rather use a revocable trust. I have way more flexibility there, right? I can rip it up, I could change it. You would use an irrevocable trust primarily for two key reasons. One would be asset protection of assets, and the second would be to avoid any death taxes or estate taxes is the term that we would use. Because they are legally distinct entities, if I no longer own that asset and the irrevocable trust owns that asset, there could be some creditor protection and some estate tax avoidance benefits that you can accomplish with using those trusts that you cannot get with a revocable trust. So because you can revoke it, it's really just an alter ego of you. It is really formed primarily to avoid probate and to provide maybe management over assets while you are alive, but it will not avoid estate taxes. And absent maybe some specific states that maybe allow for some asset protection, it generally does not provide much or any asset protection over assets that you contribute to that trust, which is really when we meet a family and we're going through an estate plan review, I've heard many times families, I have a trust. And we ask, well, is it a revocable trust or is it an irrevocable trust? I'm not really sure. Or I think it's irrevocable. I think I have the asset protection there because I've already had that trust. And we find that, number one, not only is the trust not funded, which is a key component, because if I have the trust drafted, but it's not funded, that doesn't accomplish anything. And usually it's a revocable trust, which again does not provide much, if any, asset protection. So that's a really key distinction. Hopefully that answered your question on the two key differences between them.
Yeah, if I'm understanding you correctly, what you're saying is a revocable trust is effectively a set of rules that takes effect when you die. When you pass away, does a revocable trust become irrevocable at that point?
Yes, correct. So that's a key component. Yep.
And if I'm, make it when I'm 45 and when I get to 55, I have different set of assets or maybe a different family situation, I can just keep making changes so long as I'm competent to do that.
Correct.
Until such a time that I feel like it's perfect or the inevitable happens. Now with this irrevocable trust, it sounds like you might use that if you just are like, I don't need this money now. I am happy to have this out of my life and move it to the next generation, and I can use that to effectively avoid estate tax. I mean, is it really that simple? I want to get into the advanced planning strategies and talk about avoidance of estate tax later. But I mean, is it really as simple as oh, hey, I don't want this to be part of my estate. So here, I'm going to drop it in this box. And now it's not part of my estate, and the next generation has it.
It can be. I wouldn't advise a client to do that because it is an irrevocable trust. So, really, again, getting back to these decisions on picking trustees and really how you want that trust drafted from a language perspective, how should the assets be distributed out of that irrevocable trust for my kids becomes really, really important for a variety of reasons. We'll talk about, I think, probably asset protection generationally as well as for while you create this trust while you're alive. But it's not as easy as simply just drafting a trust and moving assets in there. It can be, but you're probably creating some additional exposures that if you had spent a little bit more time going through a maybe a more detailed, thoughtful process, you could avoid.
I want to come back to this one and talk a little bit more about it as we get later into sort of asset protection strategies, tax optimization, those kind of like, what do you deploy when you want to do that? But it sounds like, maybe if I work in a high risk profession where there's a risk of lawsuits, maybe if I
Right.
have some family dynamics that would require me to really think about asset protection, like these are the kind of tools you want to deploy. But you said something both about the irrevocable and irrevocable trust, the estate planning trust, as we'll call it,
Mhm.
which is you have to fund it or transfer assets into it. Explain that process to me. So I go to a lawyer, I draft estate plan, I work with you, I get a will, I now have my revocable living trust that sort of dictates who's going to manage my money, how they're going to distribute it. What do you mean by I've got to fund it?
So that's a great question. And it's one of, if I could say, the pet peeves I have about the legal profession. And as an attorney, I think I can say this, but a lot of attorneys out there, this is again very common when we review estate plans, where the family has a will that they've drafted. They have all those four foundational legal documents that we talked about at the beginning, including a revocable living trust. And they have that in place, but it has not been funded, as we say. And remember, the main reason why you would incorporate a revocable living trust is to avoid probate. And what I said earlier is that it has to be owned by that trust upon your passing. So if you have not changed legal title, meaning if you have a bank account, you can change the bank account instead of being owned by Michael Parise, can be owned by the Michael Parise Revocable Living Trust. You've changed the title of that asset to the revocable living trust. You can do that with real estate. You can do that with investment accounts. Certain assets you cannot do that with, like retirement plans. They have to be owned by an individual, which is another area that maybe we have time to get into. We could talk a little bit about retirement plans and estate planning, but generally speaking, you would want to change the title to that revocable living trust. If you don't do that and you pass away, then everything becomes probatable because it's an asset that you own in your name at your death. And that's really where, again, a lot of clients we meet, well, I have a revocable living trust. I don't have to worry about probate. And then when we actually do a little bit of a deeper dive, we see, okay, well, it hasn't been funded, or there's still other assets that you could move into that trust to avoid probate. So that's what we mean by funding the trust, is really changing the legal title to the name of the trust in order to avoid probate.
So you can create the will, you can create the trust, but if you don't go to your bank and go to your broker and go, go to the local lister and
Yep,
move assets into that trust legally, then it doesn't really matter. It's all for naught because it goes through probate anyway.
that's correct. And
All
so
right. I mean,
that's why I said
that
it's one
sounds
of my
like a
pet
huge
peeves.
potential risk.
It is, and that's why I think that again, when I kind of talk to my peers that are in the estate planning realm, and that's one of the biggest detriments that I see is that a family client goes to an attorney, they pay a good sum of money to get these package of documents drafted, and they think that they've avoided probate, and the attorney. I mean, I would argue it's really, I think a lot of times the attorney's responsibility to make sure that that second step gets completed in order to avoid probate, because that's why you drafted the document in the first place, really. If you didn't want to avoid probate, or maybe you're okay with your estate plan being in the public realm, then in many ways you don't really need a revocable living trust. But if you're going to go to that step and oftentimes maybe pay a little bit more money to get that document drafted for you, then I think the attorneys should take that next step to be able to make sure it's funded. So for anybody who's listening out there, that's kind of a key thing you should look at if you have some of these documents, is just make sure that they've been funded appropriately.
That sounds like a good thing to check. But I think about it like a dentist, right? My dentist, every time I leave the office, he reminds me to floss, reminds me to floss. But like he can't come home and floss for me, right? So
Right.
even if you walk out and the attorney provides that checklist and tells you how you have to do this, I mean, is this part of why you guys are not just a law practice, but a wealth management practice? You guys do the investment management. Is it my understanding that you guys work with your clients to sort of make those changes?
Yeah, so that's very often what we would do as the attorney on staff of Copper Beech. I don't represent our clients legally. I represent them within the context of Copper Beech, but we are that holistic planning type of firm. We often refer to ourselves as a family CFO firm because we often say that our clients are, maybe great CEOs in one area of their family, but there are other areas that they maybe are lacking. Not their fault. They just don't have that quarterback advisor that's really overseeing and being proactive with them on some of these issues. And so estate planning is one component of what we do. And that's another important, I think, a thing to mention is, estate planning is vitally important to do and to spend the time to make sure that you have a properly drafted and curated plan. But it really, at the end of the day, is one component of what a holistic plan is. It really gets tied in with what is your retirement plan? What is your investment plan? In fact, very often when we go through financial projections for our families, many times the family has actually made different decisions in their estate plan because they've been able to look at some of the forecasting that we've done for them in terms of, well, maybe I'm not worth a lot of money today, but if you forecast out over the next 20 years, maybe they own a successful company that's growing, or we've been through, a 15-year bull market in the stock market where now they all of a sudden can look in the future and say, wow, that's a lot more assets than I really thought I'm either worth today or I would be worth. Maybe I should draft my documents a little bit differently. Maybe I should have more of an asset protection focus in my estate plan than I thought I wanted, because now I'm seeing this holistic approach. That's really key. Again, estate planning is very important, but if it's done within a vacuum without having the rest of the components of that plan put around it, there could be some exposures there. It could maybe not be optimized as well as it could be if you had incorporated the whole picture holistically around that estate plan.
You can't really know what your estate plan is going to do if you don't do the math, right? And how
Yep.
many times have you sat down with an attorney who actually sits a spreadsheet in front of you and says, hey, look, in 10 years, 20 years, 30 years, 40 years, here's what your wealth might look like if it compounds at these rates, and you might make very different decisions because of that.
Sure.
Speaking of the trust, right, you mentioned two things that I want to get to, right? You mentioned taxes, which we haven't talked about trusts and taxes yet, but you mentioned that it doesn't really have much to do with taxes. I want to understand that. And you mentioned retirement accounts. Americans hold, if I recall correctly, something like $25 trillion between IRAs, 401ks, 403bs, but it's these individual retirement accounts and qualified retirement accounts.
Yep.
How are they treated? You said that they can't be titled into a trust. Does that mean, like, if I have a big IRA, if I got $5 million in an IRA or something, it's going through probate no matter what?
So retirement accounts avoid probate because they have a beneficiary attached to them. So when you if you're working in a company and you have a 401k plan, you have paperwork when you sign up for that plan through your employer, and you would have a beneficiary designation on that account. You'd usually name a primary beneficiary and then a contingent. But normally it's a spouse, and then you would name your children as the contingent if you have children.
Okay, so they just bypass the probate process, the trust process entirely, basically, so that
If
they're
you,
not public, at least.
They're not public. That is correct. Now, it's still very important to have those beneficiary designations looked at in the context of an estate plan. And I'll tell you why. Because very often we see families draft an estate plan and maybe they want to incorporate trust for their children or their descendants long term, but they have this other IRA or 401k plan over here where they name their spouse or their children as those individual beneficiaries of that account. Now, that will avoid probate if you were to pass away. So it stays in a more private succession plan, but it bypasses your will and that revocable trust that you formed as well. So if you want to have your assets in a trust format and going down the generational line, that path, it's also important to make sure that you understand how those other accounts may transition down the generational line, because it's very common that they will go in different directions. They may get to your children, but they may get there in a less asset protected format, depending on how you filled out that beneficiary designation. So again, this is like within the context of a holistic plan. These are the things that we look at with our families to make sure that at least the client is aware of how things will flow in the event that they were to pass away.
So I think that's a pretty good coverage of the role of this revocable living trust in the estate plan. Before we start to get into taxes, which I think is really probably the biggest subject everybody wants to hear about, let's round out those 4 items. So you mentioned a healthcare POA and you mentioned the financial POA. You explained the purpose of the financial POA, right? It's, my estate plan hasn't kicked in. I am incapacitated. Maybe I'm in a nursing home. Maybe I have Alzheimer's, that kind of thing.
Yep.
Is that
Yep.
correct on the financial? Okay. And what about the healthcare POA? What role does that play in the estate plan altogether?
Well, it can take a few different roles. Think about somebody becoming incapacitated. Maybe they get in a car accident and they're unconscious and they can't make healthcare decisions on their behalf. You would nominate somebody to work with your medical professionals to be able to make sure that you get the care that you need and making those decisions on your behalf because you can't make them on your behalf. The other component of it is more end of life decisions. So if you have a terminal condition where you are unconscious and you have usually it's 2 physicians certify that you are not going to be able to recover from that. Usually that's where you would nominate somebody to either withhold nutrition or hydration from you so that you can pass away peacefully versus staying on maybe it's like a respirator or some other medical device where there's really not a high likelihood for you to recover from that condition. So it deals with those situations where, and there's been a lot of public cases on that over the years in the news where you have family members that are fighting against each other regarding how they want that situation to be dealt with. And this is, again, why having these documents is so important, is that you're laying out how you want that situation to occur. So there's no family strife. There's no confusion or ambiguity regarding how you want that situation to transpire. So those are the 2 main reasons why you would have a healthcare power of attorney.
That makes sense. I feel like I'm sort of living inside an episode of The Pit right now. So maybe we'll move back out of more, into more comfortable territory and get back to talking about money. When I think about my estate plan, when I think about relatives who have passed away, like I have 2 big concerns. So why don't we start with those? My first concern is sort of, hey, what about while I'm alive, how much of my money is going to end up going to sort of end of life care, right? Nursing homes, I've seen quotes of $5,000, $8,000, $10,000 a month just for the living arrangements, let alone the medical care, things like that. And then, of course, the ultimate sort of cost, taxes, right? Though my understanding is the estate tax is only for the sort of uber wealthy. So why don't we dig in here first?
Sure.
You talked about asset protection. What can people do to try to limit the exposure, the risk that they get from end of life care costs?
Normally, the tool that would be used would be an irrevocable trust. So that would be one of the areas where having an irrevocable trust could assist in that objective, because it is a legally distinct entity. So if assets are owned by that entity, they are no longer owned by the individual. So very often, this is sort of a subset of estate planning called elder law care, where there are actually attorneys that they specialize in this. That's all they do all day, every day. And really what it's designed to do is to protect assets, to ensure that if there is the need for end of life care, that that individual can qualify for governmental assistance without having the assets of that trust be exposed to either repay for the governmental assistance or have to be spent down in order to qualify for benefits. Usually Medicaid is an area that there's certain qualifications that you have to meet. You can only own a certain amount of assets, a certain amount of have a certain amount of income as a part of that. And so utilizing trusts could be a way to help with that. Now, there are very strict requirements in order to qualify for that. Many states will have what they call a look back provision, where they assume that if you move assets out of your ownership, either to a trust or to a child or even a sibling, there's been a lot of cases around that if you do that within a certain period of time of applying for Medicaid assistance, that they will claw back those assets as a part of and basically not allow you to qualify for benefits until those assets have been spent down. So it's really important that you talk to a qualified attorney that deals with that every day to make sure that you're planning appropriately if that is a concern that you have as a part of your plan.
Yeah, and I realize you are not an elder law attorney. You focus on the financial management side, but you probably know this well enough to at least answer this question, which is you mentioned this look back, and I've heard these stories like, hey, mom went into a nursing home. The main asset she had was the $2 million house in Connecticut, and Medicare took it, Medicaid, I think,
Yeah.
took it. I think what you're saying is you can transfer those assets out, but you got to do it soon enough. And how soon?
It really depends on the states. Most commonly, it's around 5 years or 6 years is the look back. So all states have different rules around that because Medicaid it's a part federal law and part state administered law as well. So every state is going to have slightly different rules around that, and that's why it's again important for you to talk to a qualified attorney that deals with that in your state of residence because there could be drastically different answers to that question depending on where you live. It's really
And
important.
if someone engages your firm for wealth management, are you helping to coordinate that process to find that attorney to get that built?
Correct. So yeah, that would be if that's something that we would recognize as being a concern, then we would go out and find an attorney that is in that client's state of residence that would be qualified to handle that role, and then we would refer and bring in that expert to handle that, and we would coordinate with that attorney as well to make sure that they have an understanding of the financial situation of the family, so that it helps them do their job a lot easier.
All right, let's turn to the other subject. Right, we've talked enough about death and dying and that side. Let's talk about the other side of the inevitables, right? Death and taxes, because I think at least for me, and I imagine for very much of our audience, the big concern is I pass away, the money goes to the next generation, and what are the things that are going to cause it to disappear, to not be as impactful as it could be? And one of those has got to be taxes. So can you explain to whom does the fabled death tax, the estate tax, apply? And are there other taxes or government costs that we should be thinking about?
There are. I'll get to the death tax conversation in a second, but I think it's also important. You said other costs. Probate, the probate process can be very expensive depending on where you live. So there are certain states that have different laws around how expensive it is to go through that process. So very often families, if they have to go through the probate process, they will hire an attorney, usually an estate attorney that drafted the will, to facilitate that probate process on behalf of the executor. So whereas the executor is the person that the decedent nominates to manage that process, very often they will hire an attorney to sort of offshoot that responsibility too. Depending on where you live, that could be a very expensive and time consuming process. Florida, as an example, has very clear statutory guidance on how much money attorneys are allowed to charge through that probate process. So you wouldn't really call that a tax necessarily, but it is a fee and it is an expense that can sort of erode wealth generationally. So on top of the privacy issue of wanting to avoid probate, minimizing the expense of having all your estate be probatable is, I think, a really important component as well. So with that, I'll dovetail into the tax conversation.
Well, let me interrupt you before you
Sure.
dovetail in the tax conversation, because you're reminding me of a conversation you and I once had about a particularly complicated probate case. If I'm stating this correctly, you're going to have probate anywhere you have assets, right? So if you own a home in New Jersey where you live and you also own, say, a second home in Florida, does that mean you're going through probate in two states, paying that cost twice?
That is correct. That you're talking about the term ancillary probate. So you hit the nail on the head. So particularly with real estate, this becomes a very big issue depending on where you own property and how you own it. So we worked with a client many years ago that was in commercial real estate, and they owned property in multiple states. And as a part of the estate plan, we started looking at what the probate costs would be, because not only did, to your point, the individual would have to, if you were to pass away, open probate in his state of residence. Every state has the responsibility over real estate to open probate in each individual state where a decedent owns property in their name. So that became, I think when we he had, I think, 8 or 9 properties all throughout the country in various parts, the country, where that became a really big concern for him. So there's ways in which you could move assets title to those pieces of property into an LLC, and that can help avoid some of that ancillary probate. But that's another very important point. I'm glad you brought that up, because think about how long it might take to get all of that probate open in each individual state. You might have to hire an attorney in, let's say, in your example, in Florida, to be able to handle just that Florida house that you have, right? That's a really important component to consider. And of course, if you have 8 or 9 properties in different states, you might have to do that 8 or 9 times. So that becomes a really large burden for somebody to manage as the executor, and they have to be responsible for that. So usually, and that's again why probate and avoiding probate can become a really important consideration for estate planning.
Yeah, I mean, nothing against your profession, Michael, but I can't think of a time in my life where I want 9 different attorneys in 9 different states under my payroll at the same time.
Yeah.
But you raised a really good point too, which is it's not just the financial cost. Whoever you leave as executor has to clean this mess up too, right? And this client of yours, didn't he have an attorney who had helped him structure all of this into like LLCs and such?
He did. In that situation, it was one of those situations where he had an estate plan in place, but he had it drafted, I think it was 15 or so years, 20 years prior to when we met him. And the challenge was he didn't have all of those assets at the time. So that's really an important component, where continually or periodically reviewing your plan when you have large life events. Maybe you have you got married, or you had children or grandchildren, or you started a new business and you started accumulating assets, where it makes sense to review that plan, because these things can come up. So yes, he did have an attorney, but the attorney did not get in touch with him to say, hey, why don't you come in the office and we'll review your estate plan. Fortunately, he had to have us do that that task for him and bring in an attorney to help. But yeah, it can be challenging when you haven't gone through the process in a while, to make sure that you're doing that periodically.
All right, this is not the Ron Popeil estate plan. You cannot just set it and forget it. You got to revisit it if the world changes. That's
I
what
like
I'm
that.
hearing.
I like that. That's good.
There you go. I got you a new line for your
There
next
you go.
sales
Yeah.
conversation. So let's turn to taxes, right? Like we're all chuckling here. We'll all stop chuckling in about 2 seconds, because I remember my first stab at an estate plan, and I got advice. And I don't know if it was good advice, but it was advice that was like, hey, you don't necessarily want to use a trust, because a trust is taxed higher than everyone else. Help explain that, right? Like, how does the trust and taxes interact, and just explain the general philosophy on taxes and estate plans. Who do they apply to? Who don't they apply to?
That's a great question. And we could probably do a whole webinar just on that, by the way. There's a lot that we can get into on that topic. A revocable living trust, as I mentioned earlier, that's an alter ego of you. So if you were to open let's say a bank account in the name of that trust, you actually use your tax ID number for that. So there are no separate income taxes that are owed on income that is earned by assets that are owned by the trust. You pay the income tax on that as the individual on those assets. Now, irrevocable trusts are different, as where I think you're alluding to, Alex, because they are their own legally distinct entity. They will pay their own income taxes, similar to like a corporation. Corporations have their own income tax brackets. Trusts also have their own income tax brackets. And under the federal law, irrevocable trusts are very heavily taxed. They reach the highest 37% income tax bracket at, I believe, right around $15,000 of income. Whereas in the individual, it's in the hundreds of thousands of income. So they're very heavily taxable entities, which is why if you are going to form an irrevocable trust, the income tax management of the assets that are owned by that trust becomes critically important. Again, one of the reasons why coordinating all aspects of your financial plan here become vitally important, because if you just do what you alluded to earlier, Alex, I was going to form this irrevocable trust and I'm going to move assets into that trust. If you don't have a thought process around how that trust will be paying the income taxes on those assets, that could be a very big deal that you want to consider as a part of the plan as well. And there's
So
some
that
other
applies in the elder care situation you were talking about before.
correct.
If mom or dad is living alone and getting to end of life, and you're starting to think, boy, we should put this house in a trust. We should maybe move their bank accounts into a trust and manage it for them so that it doesn't get taken by Medicaid. You have to think about the taxation of those assets now suddenly go up, don't they?
They could. So that now we're getting a little bit into the weeds of the trust, and I don't mean to have get a dissertation on trust and income taxation, but there may be ways in which you can create a trust. They're called grantor trusts, and if you were to draft a trust in that way, the trust does not pay the income taxes on the trust's income, but the grantor, the creator of that trust, will pay the income taxes on that asset. Now, why is that a good thing? Well, that could be a way in which you can transfer assets to your heirs by effectively paying income taxes on the trust's behalf. If you think about it, if I have an investment account that I move into that irrevocable trust, and it's a grantor trust, which means I am the income tax payer, and that trust earns $100,000 worth of dividends, let's just say, I will have to pay tax on that $100,000 of dividend income, not the trust. So now the trust that gets to keep $100,000. So depending on the plan, that might actually be advantageous to have that occur because it might actually be able to lower the grantor's estate by paying income taxes on behalf of that trust. That was probably a little bit of maybe a 301 kind of estate planning course, but I think it's important to talk about that because there may be ways to draft these trusts in a way where you can manage some of that income tax exposure as well. One of the other things that a lot of our families utilize are very specific vehicles, investment vehicles that will actually provide a tax shelter inside of that irrevocable trust where you can invest those assets. I mentioned that $100,000 of dividend income where you don't have to declare any taxes at all. And that's maybe one of our leveraged gifting type of webinars that maybe we'll get a chance to do. That I think is a really important way in which we utilize specific custom investment vehicles to be able to manage the income tax exposure on those assets to shelter all those income taxes.
Yeah. And if I know our viewers, they don't mind you dipping into the weeds here to talk about things. We're cruising through topics here and we have a lot more to explore. I just want to quickly remind you if you're looking to build your own plan or just want to speak to Michael and his team about one of the strategies that he's gone over here today, feel free to go to worthnet.com where you'll find Copper Beech listed as one of our hand-picked advisor partners to whom we refer clients looking for help with multi-generational planning issues. You can reach out to Michael and his team for a free consultation, and they'll walk you through their approach and how they might help you build a plan intended to last for generations. Michael, moving on, as we get into these complex structures, I think it's a good reminder that you guys have a lot of tools available at your disposal and you sort of know how to deploy them for various different situations. What really matters is that you understand, right, the client's goal ultimately.
Yep. It's all there's everything that we do is really custom. And I often say that a lot of these, whether it's a trust, you mentioned at the very beginning, I think Alex Charitable Trust, which I maybe we'll get to in a little bit. That's what I think a tool in a toolbox. That trust may fit for one family, it may not fit for another family. All of these, planning strategies are really just tools in a toolbox that we have the understanding of and we can sort of plug them in where it really fits. But ultimately, the client merely makes the decision. We're not here to tell a client how they should draft their trusts if they want to go and draft the trust. We will educate them on the ramifications of how that trust language will impact their plan, but ultimately it's their plan, it's their assets, it's their family. We're just going to try to guide them to get to the right result that fits for them.
All right, let's talk through some hypotheticals. Let's talk through sort of how you would approach that guidance, and let's talk about it with tax. Let's just imagine someone who is worked hard their whole life. They've saved. They have $2, $3, $4, $5 million in assets saved and mixed with taxable retirement plans. But they're a saver. They've sort of worked for their life, not necessarily a business owner, not necessarily heavily involved in real estate. Why don't we start with that? Let's call it the simple case.
Mhm.
Right. And in the simple case, how do you have to look at taxes when you are developing your estate plan?
That's a great question. So, from a retirement plan perspective, I think there's a couple things that, particularly recently, we're seeing a lot more with our clients. And you mentioned retirement accounts and IRA. So, an IRA is what we call in the industry a qualified plan. So, that's an asset that when you make a contribution to that IRA, if it's a traditional IRA, you get a tax deduction, generally speaking, depending on your income levels, on that contribution. While it grows inside of that IRA account, you do not pay any tax on the growth, which is very nice. None of us really want to pay more taxes than we have to. But when you reach a certain age, the government says, hey, we've let you accumulate all of this wealth inside of these plans without paying tax. We want our tax dollars. So we want you to start taking distributions from that IRA account. And right now, depending on your age, it could be either 73 or up to 75, again, depending on what age you are today. So at that point in time, again, the government wants you to start taking distributions from that IRA. And that, when you take it out, will be taxed at ordinary income tax rates. So what we're seeing a lot with our clients, which is interesting, because a lot of times the government, the traditional thought is, well, when I take those distributions and I pay ordinary income tax on it, I'll probably be retired. I'll probably be in a lower income tax bracket than I was when I contributed to that account and got that tax deduction. Well, we're seeing that that's not always the case right now, mainly because a lot of our clients are probably like this simple case you just alluded to, Alex. They've done a great job saving. They've accumulated a lot of wealth in these accounts. And so even though they think they're going to be in a lower income tax bracket, they very often aren't. And so we have a lot of clients that are asking us now, I don't really want to take these distributions from this account. Well, again, by law, you have to. And in fact, if you don't take enough, the government will tax you at even higher amount if you don't take enough out of that account on an annual basis. So it becomes a very big deal. And they're asking us to come up with strategies that maybe can avoid that income taxation event. It can be very challenging. Now, on a passing away scenario, so we're talking about estate planning here a little bit. As mentioned earlier, those assets are not probatable. So they'll go to whoever you name as the beneficiary of that account. But what a lot of our clients are not aware of today, and a lot of people we talk to are not aware of today, is that there's a law that went into effect probably about 5 years ago now called the Secure Act that really changed the landscape on how IRAs were inherited by your children from a taxation perspective. So let's talk a little bit about that from what the old law was. So if I inherited an IRA from a parent, okay, this is not between spouses. Spouses, if you inherit an IRA from a spouse, there are pretty favorable tax laws where the spouse can take those assets and essentially contribute them to their own qualified plan or their own IRA. So this really only applies when you're leaving assets generally to children. All right. The way the old law was, if I inherited that IRA from a parent, I would have to start taking distributions from that IRA, but I could distribute those assets over my life expectancy. So today, I hopefully have a long time to live. I only had to take a really small amount out because my life expectancy is longer actuarially. So that allowed for the assets to remain in the IRA growing free of income tax, and I could only take up small amounts out as I needed them. Well, 5 years ago, under the Secure Act, the government saw the 25 million, or excuse me, trillion of assets in these qualified plans. And as we all know, the government is hurting for tax dollars right now. I think we would all probably agree on that. And so they changed that law. That law was called the stretch IRA. Some of your listeners may have heard that term before. That was called the stretch, because you could stretch that income over your life expectancy. Well, the Secure Act changed that. So now if a child inherits an IRA, and there are some exceptions to this, but we'll keep things, generally speaking, probably 9 times out of 10, this is what will happen, is that child now has to fully liquidate that IRA within 10 years. So they can no longer stretch that IRA over their life expectancy. They have to fully liquidate that within 10 years. So at ordinary income tax rates. So it's very much more heavily taxed, generally speaking, than, let's say, if I owned a stock in my name and I sold it, I would pay capital gain tax, which is a lower rate. Right now, the ordinary income tax rates are as high as 37%. So it's much less tax efficient generationally now to really, in many ways, to own IRA accounts than it used to be only 5 years ago. So that's, I think, a very key distinction.
I really want to make sure I understood those two, because you talked about taxes during my life. This idea of the I think they call it the RMD, the required minimum distribution, correct? Right. And so I've saved, I've got money in a 401k. I'm 70 years old, I'm 80 years old. Like now I need to start taking distributions from my retirement account. And I've read that many times. Hey, contribute to a retirement account. Your taxes will be lower when you get older, or probably will be lower when you get older than they are during your peak earning years. I'm a really active bond investor, and there's this concept in bond investing of interest rate reinvestment risk, right? This idea that like if you buy a bond now and you buy it for say 10 years, you don't know what the interest rates are going to be in 10 years. So there's a value to buying a 30-year bond instead because you take away the reinvestment risk. Don't you face the same thing with taxes, a 401k, and IRA? Aren't you making a gamble that tax brackets are going to remain where they are as well? Like, if taxes go up later on ordinary income, if instead of 37%, we're looking at 40%, 45%, something closer to what you might see in Europe, that into itself is another risk both within your lifetime and across generations when you make this tax deferred investment. Is that not right?
100%. You are really making that bet. And I think if when we poll audiences, if we're speaking or we're talking to clients, we ask them how many people think taxes are going to go up or down. Everybody says that they think taxes are going to go up over time because we're fighting large deficits and all the debts that we have at the federal level. So that's a very, I think, astute point you made, Alex. When you're contributing to these accounts today, if you're my age, I may have 30 some odd years before I need to start having that required minimum distribution. I don't know what the tax laws are going to be at that time. So that is a risk that you have to consider if you're contributing to those types of accounts.
So part of estate planning isn't just the wills, the trusts. It's thinking about, it sounds like, even now, even at a young age, what kind of accounts do you contribute to? And how do you have the sort of, if you will, the right balance, the right risk exposure to future tax rates, to forced withdrawals? And now let's talk about that what do you call the stretch rule versus the secure act. Let me make sure I understand that. If my kids inherit my IRA, they have to pay taxes on that. So I thought that all of my assets up to, what is it, $30 million a couple, just aren't subject to an estate tax. I thought that the estate tax only applied to assets above 30 million bucks.
That is the estate tax. The tax that in this example with the Secure Act is really an income tax. It's called income with respect to a decedent. So because the account value, remember, you deducted the contributions to that account up front. So those assets haven't been taxed income tax wise. So this is separate from the estate tax. Now, the estate tax component, when you add that to the income tax, can be a big issue for those families that are successful and they are over that $30 million threshold, spouses, where that estate tax would kick in, the federal estate tax, where these assets in your IRAs, they have to be a part of your estate as well. So very often, if you are subject to that federal estate tax and you have an IRA that you have not paid tax on, you might lose up to 70 to 80% of the account value because you have the income tax that hasn't been paid, plus the estate tax, which right now the highest rate is 40%. So if you combine 37% highest income tax bracket, 40%, you do the math, that's how you come up with that number. So IRA accounts may be good accounts to utilize while you're living, but they're not very good accounts to die with, unfortunately, under today's tax laws. So something, again, to keep in mind as you're doing your planning. And these are things that I think you hit the nail on the head as well. Estate planning is very often people think that it's just the document, the legal documents, but really we look at it from a holistic, almost financial planning, investment tax perspective as well, not just the estate planning components.
What strategies can people take and at sort of what different life stages to try to mitigate this stealth estate tax, if you will?
I think what we're seeing a lot of, two answers, I think, to that. Number one, Roth accounts. So an astute listener is probably saying, okay, yes, I understand on the traditional IRA, but I can use a Roth account. Roths are vehicle or account registration where, unlike a traditional IRA where you get a tax deduction on a contribution, you do not get a tax deduction on the contribution to a Roth account. It's using after-tax dollars, but it also grows entirely free of tax, and you are not subjected to those required minimum distributions. and you are no longer taxed on the back end when you take
Yeah,
distributions
but
out of that.
Roth IRAs have sort of very severe income limitations, right? Like if you make more than, I think it's like $80,000 a year for an individual, you can't even contribute to a Roth IRA,
That's
correct?
correct. Correct. Now, there are ways in which you can do backdoor Roths where you can make non-deductible contributions to an IRA and then convert to a Roth. There are some ways in which you can get assets into that Roth world, we like to say, but you're absolutely correct. You're subjected to very strict income limitations in terms of if you make too much money, you don't even have a Roth IRA as an option. In addition to that, your contribution limits for a lot of families might not be sufficient. So the maximum amount I think today you can contribute to a Roth IRA is about $7,000. So for those individuals that want to save beyond $7,000 in a Roth type of concept, we utilize what we call more of our super Roth or our Roth alternative vehicle as a way to help those families, which we can get into if you think that is a good time to get into that structure.
Yeah, let's expand on that super Roth, if you will, or you said a Roth alternative
Mhm.
for a minute. With like, what kind of structure is this? I don't think I've ever heard of that.
Sure. The structure we're going to talk about today, we talked about two tax favorable ways to invest money where you're not going to pay income taxes on the earnings. One is that traditional IRA or 401k plans operate the same way. Roth IRAs are the other more commonly understood vehicle with which to do that with. The two most misunderstood vehicles are an variable annuity or an annuity contract and also a permanent life insurance contract. Under both of those structures, you do not get a tax deduction for the contributions to those accounts, but you will grow those assets entirely free of tax. And depending on which vehicle you utilize, so on the annuity side, any distributions from that account are typically taxed as ordinary income. On the permanent life insurance structure, those assets, when you take them out, are not taxed via withdrawals of basis or low interest rate tax free loans against the cash value of that permanent life insurance contract. So the permanent life insurance contract is really what we focus on a lot with our families when we talk about this super Roth alternative, because from a tax perspective, it operates very similarly to a Roth IRA. However, you do not have any of the contribution limits that you have in a Roth IRA, and it does not matter how much money you make, you can contribute to these types of vehicles, unlike a Roth IRA. So I just threw
I've
a
sat
lot
through a
at you there.
lot of investment pitches, Mike, like a lot of them, right? And I've certainly sat through 100 pitches for annuities, whole life, universal life, variable life. In my experience as an investor, I always look at the numbers and I'm always like, this doesn't work. Like it rarely made sense to me. And in fact, some of the people, to be frank, in that industry have made my skin crawl a little bit when I've tried to talk to people about like sort of whole life and stuff. Help explain this a little bit better. Like what is this permanent life insurance you're talking about? That sounds like whole and universal life to me, which is a
Mhm.
policy that's not term, right? Permanent versus term, like 10 years, 10 million bucks for, $3,000 a year. You go to Mass Mutual.
Right.
Can you explain like when does it work? When does the math make sense on permanent life insurance or these annuities?
Well, I think from a permanent life insurance standpoint, I think the math works for anyone that has a sizable account size that they want to invest on a tax efficient basis. Now, to get back to estate planning for a second, as I mentioned a little earlier, your IRA accounts, they cannot be owned by a trust, an irrevocable trust. With these permanent life insurance contracts, you can own them inside of an irrevocable trust, so you can gain that level of asset protection or removing those assets from your estate from an estate tax protection standpoint. So sometimes the amount that you want to contribute to these structures, I don't want to say is irrelevant. However, if you have a strong desire to incorporate those asset protection features, you can really create this type of structure with any amount of money. We have some families right now where they have mom and dad that wants to make gifts to their two daughters. They want to be able to put money aside for their children, for their future retirement or their future educational needs. And remember, they cannot contribute to this Roth IRA. In this case, they're over that income tax threshold or income level threshold rather. So they are utilizing these structures, and they're making contributions of gifts of around $50,000 to this permanent life insurance structure that is more of a variable contract in nature. So this is not your whole life insurance contract. This is not your universal indexed universal life is another common life insurance product that is often used. This is a custom designed variable contract where you can invest into mutual fund like type investments, just like you would in a Roth IRA. So investment wise, it works almost identical from that perspective. But unlike traditional life insurance, there are no surrender charges that are paid, which means that the account is fully liquid. That's a big downside for traditional life insurance, is that the agents that sell those products to clients, they get a commission generally for selling that. That's how they get compensated. And because the insurance company pays that commission, they assess surrender charges to the client if they wanted to the next day surrender that contract, and maybe they felt like they made a bad decision, they want to pull that money back. You have very limited liquidity in that example because the insurance company paid that insurance commission out to the agent. So this is a wholesale, more custom structure that does not have commissions, means it is fully liquid the next day if you wanted to do that structure. So I'll stop here. I just threw a lot at you there, but hopefully that answered your question a little bit.
Yeah, it does. It's interesting you mentioned that. I mean, I that's one of the things I recall from my discussions with people about things like variable life is 10-year, even 15-year sort of surrender charge periods. Always
Yeah.
felt like I was locked in. I've got to make that $50,000, $100,000 contribution year after year after year, and if I don't, there's risks to the policy, or if I need to access that capital, it's sort of locked in there forever. So
Yep.
you're saying the insurance that you're talking about as an estate planning tool here generally doesn't pay these commissions and thus doesn't have these sort of lock-in periods?
That's correct. It's more of we call it an advisory contract. So these contracts are really issued through registered investment advisory firms, where the advisor that gets appointed to manage that account would manage that account just like they would if they were to manage a taxable brokerage account on your behalf. So there are no commissions that are paid to the firm that is managing that portfolio. It's really just like any other type of investment account that could be managed by that advisor. So these products are fairly new in the industry. There's a large push in our industry to maybe move away from the old world of life insurance because of how, let's say it's been abused over the years, like you alluded to, Alex. And so these are newer contracts that are being developed to accommodate those clients that want to use this Roth IRA alternative, but they don't want to move to that structure where they have limited liquidity or they're getting pitched that insurance by the agent. They want to have this advisory fiduciary level of service over their life insurance, just like they do with any other account that they manage.
That's interesting. I don't want to turn this into a commercial for life insurance, right? And I'm sure I'm going to get a little bit of hate mail for anybody who's listened in this long from the insurance industry, but that's interesting. It sounds like sort of a whole. This is something very different than I think the insurance products that I or you may have heard of over the past 20, 30 years. There's a lot of people out there who call themselves financial advisors with an O, but not all of them are fiduciary advisors like a registered investment advisor is, who's buying this product sort of direct, if you will, from the insurance company, it sounds like. Are there other tax situations that people in this, let's call it this sort of the basic planning, I've got a retirement account, taxable accounts, anything else that you should be thinking about, like taxes on the next generation after they inherit that trust?
Well, I think some of the benefits that come along with, let's say, a taxable account is under the law right now, we have something called the stepped up income tax basis. So this could be a benefit for you if you own a taxable account in your name and you have significant gains in that account. If you were to pass away, the basis of those stocks, or if it's an example, a securities account, will step up to the date of death value so that when your heirs liquidate that account, they will not pay capital gain taxes. So there maybe actually be some benefits to holding those assets in your name until you pass away, depending on your situation. But generally speaking, if you don't want to wait until you pass away and you're going to be trading that account, you're going to have to be very careful with how the tax management of the trading of that account, because as you trade that account, if there is a gain in that, if you buy a stock in your portfolio, there could be a capital gain assessed to that stock if you were to sell it at a gain. If you have a dividend, that's also taxable. You mentioned interest rates on bonds before. Interest is taxed at ordinary income tax rate. So the management of that portfolio becomes really important from a tax perspective, because if you look at sort of the studies generationally, the amount of wealth that can get eroded from poor income tax management of portfolios is tremendous. If you look at sort of the net composite rate of return is the term that we use in portfolios, from an investment management perspective, net composite rate of return is really the return that you see on your statement minus the fees, minus inflation, and minus taxes. Those are the three components that really comprise your net composite rate of return, which is almost your real return if you think about it. So if you have somebody that is earns 10% on their portfolio and they're in the highest income tax bracket at 40%, well, now you just lost 40% of that 10%. Okay, plus fees, plus inflation. As we all know, inflation's been a little bit more in the conversation in the general economy these days than it had been for a long time. So it's really important that from a tax perspective, inflation's tough to manage. That's difficult for anybody to really manage in terms of their portfolio. But taxes, we can utilize these vehicles like this, permanent life insurance structure that we alluded to manage some of that exposure long term as you're passing that wealth down generationally.
What about as we move up in, let's call it, complexity? In addition, not everybody just invests in stocks and bonds. A lot of people invest in real assets, real property, real estate, as it's commonly known. What are the estate implications of real estate? What are some of the mistakes you see people make with real estate on estate planning?
Well, real estate is very unique from an asset class perspective, as you just alluded to. So, from an estate planning perspective, there's a few things that we really see pretty routinely, and it does come into play a lot with using irrevocable trusts. So, very often, as we alluded to, having an irrevocable trust that has these asset protection features associated with that, if we were to transfer that property to an irrevocable trust, remember, depending on how that trust is drafted, if it is not that grantor trust that I mentioned earlier, if it's a non-grantor irrevocable trust, then it's going to be taxed at the highest income tax bracket. So if it's a commercial property and you're generating rental income and you don't have depreciation that can offset that rental income, that's a big issue that you have to be concerned about. And then as well, on the sale of that property, that will trigger a capital gain on that sale as well. So we see a lot of families that if they're using trusts in their estate planning to own real estate, they're looking at it more of a 1031 exchange. If you're familiar with that term, that's a very common tax maneuver that a lot of real estate investors utilize. So what that means, if you're not familiar, is been in tax code for 100 years, probably, maybe even more at this point. But what that allows you to do is that if you were to sell that property and trigger that gain, if you take the proceeds from that sale of that property and reinvest those proceeds in a like-kind exchange in another commercial real estate property, you can defer the payment of that capital gain and not pay taxes on that sale. So that's one way that we're seeing from an estate planning, both estate planning and an income tax management perspective, to be able to avoid those income taxes on real estate investing.
Yeah. One thing as a real estate investor, it's always sort of bugged me about this. And I hear this a lot, especially from people who have been in this industry for a long time, is when you sell in a high market and you have that 1031 sort of proverbial gun to your head because you only have so much time to make that exchange, you also have to buy in the high market. What happens if you're a real estate investor and you're thinking to yourself, hey, I've accumulated a dozen rental properties, prices have never been higher. I want to realize some of this liquidity and move it somewhere that I'm not worried that prices are going to fall or going to stagnate for decades. I want to move it somewhere like to bonds or stocks. Now, how do you manage that in terms of, estate planning and thinking about this long-term ownership of real estate?
Well, I think there's a couple areas that come to mind. One, opportunity zones are another area that actually, under the most recent tax laws, that Congress renewed a lot of the provisions from the first Trump tax cuts, which established opportunity zones. Though how that law works is if you roll a gain over into one of these opportunity zone funds, you can defer the payment of the capital gain tax on that asset. And if you hold it for a certain period of time, you can bypass the capital gains entirely. So that might be one way that families would look at if they don't want to necessarily go to have the proverbial 1031 exchange to their head, where they have to find that replacement property. This could be an interesting alternative as well. It might be important to mention there are certain investment vehicles that are almost 1031 exchange off the shelf that don't require you to meet those strict deadlines. Then the deadline is about 45 days after you sell the property, the original property, that you have to identify this replacement property. Well, that's not a long period of time to negotiate the sale of a new building. And so there are investment vehicles that you can utilize to move into that will sort of allow you to satisfy some of those strict requirements, but still qualify for the 1031 exchange. So there's a little bit more flexibility on that side as well. We can utilize some of these permanent custom life insurance vehicles could become a way in which, if they're structured properly, where, again, because of the tax benefits of permanent life insurance, where any asset that is bought and sold by that life insurance contract will not pay any income taxes, there may be ways creatively to utilize those structures to help not be subjected to that 1031 requirement, if you want to use that term, and still get some tax benefits from the investment of real estate over longer periods of time.
Oh, interesting. And is that because the asset held inside the life insurance policy isn't taxed at all when it's sold, so you don't need to make a 1031 exchange? It's only,
That is correct.
and then life insurance. Let's talk about life insurance for a second. So where does that fit? Even more traditional life insurance, things like term, things like this permanent, where does that fit into an estate plan? And is my understanding correct that it's not just about, hey, I died, here's a $5 million policy to make sure my wife has enough assets to cover the loss of my income, but life insurance itself can be used to sort of like offset certain taxes like the estate tax?
That's correct. So we often say that the estate tax is more of a voluntary tax. We say that a little bit tongue in cheek.
Voluntary tax. Yeah. Yeah, sure. You tell
Yes.
the IRS it's voluntary, Michael. Well,
Right.
what do you mean by that?
Now, if it's a Now, well, what we mean by that is if it is assessed, that it is not voluntary. But the government gives us a lot of tools to be able to legally avoid the estate tax via some of these vehicles. So charitable trusts, you mentioned earlier, that could be a very effective way of utilizing the law to avoid estate taxes. So under the law, if you leave your entire estate to charity, there is no estate tax that would be assessed. So very often that is a great estate tax avoidance estate plan, but not very good for your family.
Yeah, I was going to say,
I've seen a lot.
why would I mean, sure, I can give the entire, my $5 million, $10 million to the local cat shelter. Quite a legacy.
Right. And so that's where life insurance maybe could become an interesting plan. So as an example, one estate plan could be I leave my entire estate to charity and avoid the estate tax. And maybe I create an irrevocable life insurance trust. ILIT is the acronym that we use in the legal profession, that owns a life insurance policy that upon my passing, the death benefit from that policy can go into that trust, benefit my heirs. And now the charity has gotten, in your example, $10 million. And my heirs have gotten $10 million in a trust. And Uncle Sam has gotten nothing from that transaction if it's designed properly. So that's the way. That's just one example that we talk about how the estate tax in many ways is a voluntary tax, because if you do the proper planning ahead of time, you can structure things to avoid the payment of that tax via very legitimate and well-established methods like that.
Wait, let me make sure I understood that one. So you're saying if I'm just going to make up a number, $10 million, right? I can just leave that $10 million to charity, take out a $10 million or $5 million or whatever the number is, life insurance policy on myself, and then that funds the estate. And because life insurance is this correct? Life insurance is tax-free always?
That is correct. So the death benefit of a life insurance contract is entirely free of income tax as well. So that's again, an often unknown fact about life insurance. So in that example, you're exactly right, Alex. You can create that life insurance contract inside of that trust. The death benefit, when it's received by that trust, will be entirely income tax free. So charity gets that $10 million, as an example, and your heirs inside of that trust will also receive the death benefit free of tax.
Wow. That's a really interesting structure. I still love this concept. This estate tax is voluntary. Um,
Yeah.
so you got life insurance paying out to cover your estate that's otherwise effectively been donated. Doesn't that life insurance though have a pretty large cost to it? Like if I'm 70 or 80 years old, it's going to cost a lot to get $10 million of life insurance, isn't it?
Correct. So life insurance, as the older you get, the more expensive that it will get. Now, in the example of this charitable planning, there might be a strategy that might make sense is something called survivorship life insurance, which is, or second to die is the term that oftentimes gets used, where instead of just one person being the insured, maybe two people are the insured. Maybe it's a husband and wife or spouses together will be the insureds, so that at the passing of both of those individuals is when the death benefit is paid. And because there's insurance on two lives, it can be a little bit more cost effective to look at that strategy. But that's all part of the holistic plan. And that's why, again, it's really important to put all these pieces together, that that situation isn't just a life insurance decision, or it isn't just an estate planning decision. It's really putting those two pieces together, because you have to qualify for life insurance. So if somebody is healthy and they can't qualify, or they're older and it just isn't economical, then that might not be the most optimal solution here. So that's where, in that example, maybe the family wants to go that route, but there may be just another optimal strategy because of those issues. So that's all the customization that we would look at. So again, not every family wants that plan, and so not every family would even necessarily want to go down that path. But even if they do, it might not always be the most optimal strategy, just based on other circumstances.
Yeah, and that's a great reminder that, right, nothing we're talking about here is advice. We're not recommending a specific product. This isn't a solicitation to buy a security or insurance or anything of the sort. What we're trying to do is emphasize the strategic way that you guys look at estate planning, taxation, wealth preservation beyond taxation, and how many different tools are out there that an investor just might not know of. I think of myself as a relatively well-read investor. I've been in this industry for, going on about 2 decades now. It was a hobby before it became a career. Every time I talk to you, Michael, or I talk to your father, I feel like I learn about some new structure I've never heard about before. I hear some story about some creative way that you tackled an estate plan that sort of sticks out to me. Maybe I just don't think about these things. Maybe I've just serially avoided thinking about death, and everybody else already knows what an eyelid is. But for some reason, I sincerely doubt that. So tell me other ways you might avoid. Like, so, we've talked real estate, but the real challenge is business owners or farm owners or people who have accumulated significant assets, right? So if you're now above that cap, or you may end up above that cap of $30 million by the time you pass away, are there other tools you can think of that are worth just knowing about and being able to ask about when you talk to an advisor to help reduce the estate tax exposure? And then I want to talk about the next generation for a second.
Sure. Yeah, no, those are all great questions, and I think it's important maybe to back up a little bit, if we can, and touch on sort of how we've alluded to how the federal estate tax operates. But I think it's also important to talk about states, because there are still quite a few states out there that assess their own estate tax. So there could be an issue where you have both federal estate tax exposure and state estate tax exposure. So states off the top of my head, Washington State, Massachusetts, New York, they have their own state estate tax that if you live in those states, you want to be mindful of where that level kicks in, because at the federal level we talked about, right now it's 15 million per person is the what we call the exemption amount. I call it the threshold before that federal estate tax kicks in. And if you're married, you can combine them together. So you really have that 30 million is what you talked about earlier, Alex. That's at the federal level, but the state level, it may be a lot lower, maybe 5 million, 2 million. So you want to be mindful of where that level is in your state. So just as you're going through this planning, because that may necessitate some different planning. Because some listeners may say, well, I'm nowhere near that $30 million threshold, my spouse and I, so I don't necessarily need to be concerned about this more advanced estate tax, death tax planning. But if you live in a state that has an estate tax, you might. So it's important that you look at that with your advisors. And not just today, by the way, as well. This gets back to the holistic approach, because in the future, you might have that tax, or you might be slated to have that tax, just using very reasonable rates of return in either your portfolios or your assets that maybe you don't have that exposure today, but maybe you will in the future, assuming the laws stay in place as they are today. And so that can bring up a really interesting answer to your question, Alex, which is, if I think that I might have that exposure in the future, how do I avoid it? Well, that's where we might look at more advanced gifting concepts in terms of gifting assets out of your estate today into that irrevocable trust, one of these irrevocable trust vehicles that we can form, and allow those assets to grow inside of that trust, where you will, if it's designed properly, bypass estate taxes for generations if you so choose, if the trust is designed properly. Where we see a lot of folks, unfortunately, make some incorrect decisions from an estate planning perspective, and that estate tax a conversation is where they wait too long to do planning, and the asset, maybe it's a business or it's a piece of real estate, has appreciated substantially above that $30 million threshold if you're married, and now they can't move that asset without potentially paying some gift or estate taxes on that asset, versus if they moved it in when it was a lower value, they would have had all that growth occur inside of that trust. So it's about, oftentimes I say there's almost no better time to do planning than now if you think that your assets are going to grow and appreciate in the future, because we have this at the federal level, this $30 million that we have before that tax kicks in, that we want to be mindful of. So I'll stop here, but that's one area that I think is important to touch on, is both the state that you live in and any state estate taxes, as well as that gifting conversation.
That's a really salient point, Michael, right? Like it sounds like the earlier the better here. This is of estate planning isn't something you should put off until you think you need an estate, right? It's not something you should do when you're 75 years old per se, but the earlier you do it, the more options you have, the more you can think about what that future exposure impact and strategies to avoid it might be. Is that right?
100%. I think that there's really no better time than now. On top of all the things that we discussed at the beginning of this discussion here, like avoiding probate and providing a clear and concise plan for your wishes. I mean, all that is really, really important. And then you add this tax conversation potentially on top of it. It's really not a situation where you want to wait until something, God forbid, happens because you didn't get around to doing this type of planning. And it brings up one of our favorite questions we ask families is, how do you want to be remembered? It's one of our favorite questions that we ask our families. You don't want to be remembered necessarily for having delayed doing some of this planning when there's tax exposure or there's infighting amongst families because things were not put in place properly and communicated properly. So yes, start now when you have the capacity to do it, and hopefully that motivates some folks that are listening out there.
Yeah, it sounds like the best time to start estate planning is yesterday. So the second best time is today. Old expression. So Michael, we've talked a lot about all the work that can go into making sure that on your wishes are clear, to taxes and other considerations like probate costs are managed as efficiently as one possibly can. All of that to get the money to the next generation. You hear it time and again. You hear the stories, shirt sleeves to shirt sleeves in 3 generations. You can leave money to the next generation, but they're just going to spend it. What can someone do if that's a concern? Is that you just have to leave that up to chance and roll the dice, or are there things you can do to at least try to impact how wealth is managed over the next generation or two?
Yes, I think there's two key components to that question in terms of an answer. I think the first is to design your estate plan with that in mind, and having specific language that can protect those assets generationally from all of life's mishaps that can happen. And we often use the term, let's say, in-laws and outlaws. That's a term that we use pretty frequently when we refer to estate planning, because some of these asset protection risks and some of the reasons why this shirt sleeves to shirt sleeves proverb can rear its ugly head, if you will, is maybe because of poor planning and not being gone through the estate planning process in a really clear and deliberate way, where you're now creating an asset protection issue potentially for your children. As an example, we see this all the time with trusts, where I create a trust and I name my spouse as a beneficiary of that trust. And so the assets of that trust will be held for my spouse's benefit while she is alive. And upon her passing, I leave the whatever's remaining in that trust to my children. And this is where the language becomes really important in your trusts. So very often we see what we call mandatory age-based distributions. So very commonly it says something like this: I leave assets in trust for my children, but at age 25, when my child turns age 25, 1/3 or 1/4 of that trust distributes out to that child. When they turn 35, another 50%. 40 or 45, 100%. So at age, when your child turns age 40 or 45, their trust completely ends. Now they own those assets, whatever's left in that trust, in their name. That now is, not only is it exposed to their own potential financial mismanagement, hopefully they're responsible individuals, and we'll get to how we can help make them responsible individuals in that example. But there's all these things I said, mishaps in life that can happen. So maybe they have a bad marriage and they've commingled those assets with their spouse. Maybe they go and they buy a vacation house with those assets, and there's marital separation that occurs. Those assets are now likely exposed to that marital separation. And so that's one example. Another example could be, God forbid, they have a substance abuse addiction, or they have a gambling addiction. These are things that none of us want to think about, and we hope that they never happen. Unfortunately, they do. They're not likely to happen, but they can happen. And so how do we avoid these exposures, right? Well, those mandatory distributions, instead of having them, we can have a trust that's drafted that essentially says, these assets stay in trust for the benefit of my children and for future descendants. And there are no mandatory distributions out of this trust that could then potentially be exposed to those creditor claims or those asset protection risks. So I think that's really, I would say, the first answer to your question is drafting the trust appropriately to fit your needs. Now, again, not every family is concerned about that. I've had a lot of clients where they said, you know what, if my kids are not going to be responsible and they're going to those get into those risks or exposures, then that's on them. I'm going to just leave everything to them outright and free of trust. That's perfectly acceptable as long as they understand maybe some of the exposures or risks that can come along with that. That's fine. I think far too often I've seen clients, when we've gone through, and again, this estate planning review, where they didn't really understand that that's even what their trust said. They said, well, I don't want my children to have access to these assets when they are 45 or 25. I want to keep assets in trust for a longer period of time. Well, that's not what your trust says. And that's where, again, going through the estate planning process and really understanding how you can draft these documents to fit your plan is important. So that's really the first, I think, answer to your question, Alex. I think the second would be around generational governance and really educating your children around how to be responsible individuals. So financial literacy is a large part of our business in terms of teaching the next generation around how to be good stewards over this wealth that may be coming to them, whatever amount that is. And oftentimes families think that you have to be worth 50 or $100 million to have these conversations. I would argue, no. I think anybody, regardless of the level of financial capital, to have these conversations with your children so that they can understand about being, again, good financial stewards over this wealth, that they understand how to invest money. They may never become the best Wall Street stock picker, but they can have a basic understanding. And again, if you have the right trustee of that trust in place, that trustee can be a great resource to help guide your children and future descendants in how to responsibly manage those assets. That's really one component of that as well. And then also values, family values, and transferring those to the next generation become really important. So you mentioned business owners a little earlier, Alex. I think having a business and starting a business is just such a rewarding experience for all the entrepreneurs that we work with, that stories and telling stories around how you created that business so that your children and grandchildren somewhere down the road, they hear those stories. I mean, we do some legacy videos with some of our families where we'll actually sit, maybe it's grandma and grandpa down, and we'll videotape them for an hour on where the wealth came from. How did they start the business? Or, maybe they didn't start a business, but they bought real estate and they were just very deliberate and they learned how to be good investors. We tell those stories so that the next generation or future generations will be able to see that, and they'll be able to hopefully say, well, now I know where grandma and grandpa got this wealth that I'm now the recipient of. So I think there's a lot of answers to your question, but I think those two main components, financial literacy and drafting your estate plan in a asset protected mindset, I think are the two biggest ways that you can avoid that shirt sleeves proverb.
Yeah, Michael, I'm glad you shared that story of filming these I think you guys call them legacy videos, because I personally have never run into another advisory firm who does that. I've talked to countless advisory firms, and this was what really stuck out to me about Copper Beech, and a large part of why we invited you guys to be part of the hand selected network of advisors who we believe focus on some of the most challenging parts of financial planning and investment management today. And so I just want to remind everybody that Copper Beech is one of our partner investment advisors. And if you want to talk to Michael and his team about building an estate plan of your own, if you want to understand how they approach capital management, but also this management of education and your legacy across generations, I encourage you to go to worthnet.com, find Copper Beech on our listing of advisors, and get in touch. Your initial consultation with the team is free. They're available to talk you through their approach and how they would approach building a personalized plan for you. So please check them out at worthnet.com. And Michael, I just want to thank you so much for your time today. It's such an in-depth conversation.
My pleasure, Alex. This was great. Thank you for having me again.
I hope you've enjoyed this deep dive into estate planning. If you want to build a plan of your own, just go to worthnet.com, where you'll find information on how to contact the Copper Beech team. They're one of our hand-selected advisors, specifically focused on multi-generational wealth planning issues. Fill out our quick Fill out our quick 1-minute questionnaire, and you'll be connected to Copper Beech for a free initial consultation.